Exaggeration is the enemy of credibility. Recently, the court offered tips on lowering the rhetorical temperature between family law litigants. As we noted in our recent case, the court dealt with two warring spouses who attacked each other with what it called rhetorical fierceness that one would expect of a mixed martial arts cage match. Not pay-per-view, but close. As an add-on to the court's decision-making on the spouse's substantive dispute over who would get exclusive possession of the matrimonial home, the court offered some practical advice, not only for these parties, but for all litigants in the entire legal profession. The court stated, in hopes of lowering the rhetorical temperature of the future materials of these parties, and perhaps of others who will come before the court, that it repeated some essential facts, often stated at all levels of court, but which bears constant repetition. Number one, evidence regarding a former spouse's moral failings is rarely relevant to the issues before the court. Number two, nor is the court swayed by rhetorical angst against the other party that verges on agitprop. Court's decisions are not guided by concerns of marital infidelity or fidelity. A non-abusive partner can be a terrible spouse, but a good parent. Everyone is supposed to know this, but all too often the court sees litigants raise these issues for context. Fourth point is exaggeration is the enemy of credibility. It's a great line. As is often said, one never gets a second chance to make a first impression. That impression arising from the party's materials or argument is one of embellishment. That impression will color everything that emanates from that party or their counsel. Fifth point, affidavits that read as argument rather than recitation of facts are not persuasive. They speak to careless drafting. 6, similarly, hearsay allegations against the other side are generally ignored, whether judges feel it necessary to explicitly say or not. 7th, the lawyer's letter, whatever it says, is useless. Unless it contains an admission. It's not evidence of anything except the fact that it was sent. The fact that a lawyer makes an allegation against the other side in a letter is usually of no evidentiary value. 8th point is facts win cases. A pebble of proof is worth a mountain of innuendo or bald allegation. 9th, relevance matters. If the court is dealing with, say, an issue regarding parenting, allegations of the party's failures regarding collateral issues, say their stinginess or their lack of financial disclosure, are irrelevant and counterproductive. They do not reveal the dark soul of the other side or to turn the court against the allegedly offending spouse. Rather, they demonstrate that the party or their counsel is unable to focus on the issues at hand. Often these materials backfire, leading the court to place greater trust in the other side. The 10th point, one key to success in family law, as in other areas of law, is to race to the moral high ground. Courts appreciate those parties and counsel who demonstrate their commitment to the high ground in both framing and presenting their case. The 11th point, while dealing with the moral high ground, many capable counsel advise their clients against the Me Tooism, one side's failure to obey a court order or produce necessary disclosure does not give license to the other side to do the same. Just because the materials of one side are incendiary or prolix, that does not mean the other side is required to respond in kind. Judges are usually aware when a party has crossed the line. Showing that you or your client does not do the same is both the ethical and smart thing to do. None of the court's comments should be taken as a comment as the present counsel in that particular case. nor should they be seen to minimize the kind of resolute advocacy that the court has come to expect from so many of its best lawyers. That type of advocacy is often necessary and valued, but even then, rhetorical excess is the enemy of good advocacy. So what do you think? Did the court get it right with these comments? Subscribe to future videos. You can like and comment on this video or share it with your colleagues. We're going to endeavor to answer everybody's comments at the end of each week. Until next time, I'm Russell Alexander.